You also have,
Okay.
you wanna go to that?
No,
You don't wanna go to pro work?
no. All right, good morning. I have someone here from a corrections facility. Can you tell me your name, please?
Keith Michael Hall.
I'm sorry, I wasn't able to understand that.
Keith Michael Hall.
Okay.
Right.
All right, Mr. Hall, your attorney is working with another client right now. As soon as she's ready for your case, I'll have you speak to her. All right, Ms. Underwood, are you ready on Cole versus Cole?
Yes.
Is file 25-53099-PP, Alexander Cole versus Michael Cole. We are here today on an order to show cause regarding an alleged violation of a personal protection order. Ms. Underwood, would you like to place your appearance on the record?
Good morning, Your Honor. Nicole Underwood on behalf of the respondent, Michael Cole, who's sitting to my left.
And sir, you are Michael Cole.
I am.
Mr. Cole, you received a copy of the motion to show cause?
I did.
That motion alleges that you violated the terms of your personal protection order by making telephone calls and text messages to Ms. Cole, petitioner in this case. The maximum possible penalty for violating a personal protection order is up to 93 days in jail and or a $500 fine. Ms. Underwood, do you know how Mr. Cole would like to proceed?
Yes, Your Honor. The show cause order as a whole, based on all of the allegations, my client would like to take a not guilty plea at this time and set the matter for a hearing.
All right, I'll enter a not guilty plea for Mr. Cole. And set this for another hearing the other day, but I don't recall what date that was. Do you have
I believe it was the 25th at 8 a.m., Judge.
We'll set this then for, again, November 25th at 8 a.m. All right, is there anything else we need to address today, Ms. Underwood? Thank you, we're all set. Okay, we can call Kensner. This is file 25-22364-FH People versus Jonathan Tucker Ketzner. We are here today for a pretrial conference in this case and proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Thank you. Good morning, Your Honor. Isaac Sneed on behalf of the people. Ron Underwood for Mr. Glazer on behalf of Mr. Kepner this morning, Your Honor.
All right, where do things stand with Mr. Ketzner's case?
There are a few things that Mr. Glazer and Mr. Ketzner are discussing, Your Honor, as far as motions that may be filed. So we would just ask for another pretrial in about 3 or 4 weeks if we could have that, Your Honor. I would be happy to do the stip to adjourn with Mr. Sneed's permission.
I'm sorry, Ms. Arnold, this looks like it might be your case. Do you want to cover this one?
That's fine.
It doesn't matter to me. I just didn't want to hold you out if it was your case.
Right. We're just looking at adjourning for a couple weeks. That's fine.
Your Honor, this is Attorney Todd Kaluzny. I have the co-defendant on this case, Nancy Stout. I don't know if we can call these cases together and so we can keep them together.
Okay, why don't you let me call that one next? She's here, but I'd rather take them one at a time. I'll certainly proceed with the understanding that that there are co-defendants, that they haven't been consolidated to my knowledge. So, so the next available date I would have would be December 17th
Thank
at
you, Your Honor.
8:15. And Mr. Klosny, is that, if we use that day, is that going to present any issue? I assume we're probably going to adjourn Ms. Stouts to the same date.
No, that would be fine. As long as it's in the morning and on Zoom, I'm perfectly fine with that, Your Honor.
All right, so December 17th, 8:15 a.m. And that can proceed by Zoom. All right, anything else, Ms. Underwood, to address with Mr. Ketzner's case?
No, not at this time, Your Honor.
All right, Mr. Ketzner, you can let the officer with you know that you're done with court today.
Yes, sir. Thank you.
Where did this stop? Ms. Underwood, are you going to need to speak to Heath Hall?
No, I don't believe so, Your Honor. I can. I'll speak to him for a second.
Here's my lawyer, the bottom.
Sir Hall, I'm going to put you in a breakout session with Ms. Underwood if you give me just a moment.
That's not necessary. She tells you.
This is file 25-22372-FH People versus Nancy Elizabeth Stout. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Good morning, Your Honor. May it please court, Todd Kaluzny on behalf of Ms. Stout.
Okay, and we just had a brief hearing on Mr. Ketzner's case. These cases involve co-defendants, and it's my understanding we're going to adjourn this to December 17th, which would be the same date as the other case. Is that all accurate?
That is accurate, Your Honor. And it would also be on Zoom as well, just for the record.
Okay, is there anything else we need to address then with Ms. Stout's case today?
Nothing today, Your Honor. I have been in communication with Miss Arnold frequently throughout this case, and we've been working to try and see if we could resolve it. There may be a motion, I don't know, but there's nothing else we need to address on the record today.
Okay, Ms. Stout, your next date then will be December 17th at 8:15 a.m. and you can log in using all the same Zoom information that you used today.
Okay, thank you.
Thank you very much, Your Honor. Have a great day.
The changes.
Go. See, we're back in court.
Okay, this is file 24-21859-FH People versus Heath Michael Hall. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Ron Underwood for Mr. Hall this morning, Your Honor. Your Honor, this is a competency update. According to the most recent update filed October 30th by Dr. Flora Krapko, Mr. Hall remains incompetent, but they believe restorable. So we would simply ask for a 90-day adjournment, Your Honor, for this matter to proceed and to see if they can indeed make Mr. Hall competent, Your Honor.
He can't maybe do nothing.
All right, Mr. Sneed, is there anything you need to address from the people's side?
We have no objection to the adjournment. Your Honor, the 15-month date for restoration, I've calculated as April 15th, 2026. So even if we adjourn 90 days, we're still within that time frame.
Right.
Have a good day at my expense.
All right, let's go with February 18th at 8:15 a.m. for another review hearing to see where things stand and whether Mr. Hall's been admitted at that point.
Did you say the 8th or the 18th, Your Honor?
February 18th at 8:15.
And I will be happy to do this stip in order with Mr. Sneed's permission.
Thank you.
Bye. Have a good day.
All right, thank you, Mr. Hall. You're all set. And Mr. Sneed will need a Zoom writ from the prosecutor's office as well.
Understood. Thank you, Judge.
Hello.
Okay, Ms. Cole, I apologize. I did not see you in the waiting room when I called Mr. Cole's case for the alleged contempt. I can tell you that he did plead not guilty to the contempt, and I set it for a hearing on the same day as our already scheduled hearing on the motion to terminate the November 25th.
Okay, so we'll just kind of do all that together.
Yeah.
Can that be done? Is that as Zoom as well, or will I have to be there?
For that hearing, I will need to have you in person.
Okay. Okay. I know I was there yesterday.
Yeah. Okay, you're all set then if you want to log out.
Okay. So same day, I'll see you guys there.
Thank you.
Thanks.
Ms. Underwood, I believe Mr. Collar is here in the courtroom. Are you going to need to speak to him?
Could I believe, yeah, I need to speak with him.
Hello?
All right, Mr. Collar, if you give me a second, I'm going to put you in a breakout session with Ms. Underwood.
All right. What's up, brother? How you doing today? Sorry for interrupting today. All right. What's your best, Bubba?
Call the jail, tell them the jail's 3D device, the camera's on.
The jail Zoom their devices, the camera off. Okay, very good. Thank you. Bye.
All right, I have someone here that just got pulled into the meeting on a Samsung device and needed to start your video, unmute your device. And can you tell me your name?
Megan Cooper.
Okay, Ms. Cooper, I'm going to put you in the waiting room for a couple minutes.
Okay.
I have someone here. I've just pulled in on a Samsung device. All right, sir, can you unmute your device, please?
Yes, you got me, sir.
Yes, I can hear you now. Can you tell me your name?
My name is Eric Cooper.
Mr. Cooper, I'm going to put you back in the waiting room for a couple of minutes and I'll bring you back in when I can call your case.
Yes, Your Honor.
Ms. Underwood, are you ready to proceed with Mr. Collar?
Yes, Your Honor. Thank you.
Okay, this is file 23-21350-FH, 24-21823-FH, 24-21823-FH. Those two are set for probation violation hearings. Also file 24-22084-FC and 25-22161-FH are set for pretrials. We are proceeding today partially in person and partially by video conference today. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Your Honor, are we talking about Mr. Collar?
Oh, I'm sorry. I read a bunch of incorrect cases, didn't I? I'm sorry. All right, so let's try this again. It's file 23-21350-FH, 24-21823-FH. Those are both set for probation violation hearings. The other cases are other defendants. So, all right, go ahead then, Ms. Underwood.
Thank you, Your Honor. Rhonda Underwood representing Mr. Collar. Your Honor, there has been a recommendation in this matter by Mr. McCarron of termination with Mr. Collar simply continuing on his probation he currently has in the district court. And under those circumstances, Mr. Collar wishes to enter a plea in this matter.
Mr. Collar, would you raise your hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Brian Cody Collar, correct?
Yes, sir.
Mr. Collar, have you seen copies of the request and summons for probation violation?
Yes, sir.
Do you understand that alleges that you failed to do your drug screens through your probation office?
Yes, sir.
You had in file 24-21823-FH pled guilty to use of cocaine. Do you understand that the maximum possible penalty for that offense is up to 1 year in jail?
Yes, sir.
In other file, you had pled guilty to attempted assaulting, resisting, obstructing a police officer. You understand the maximum possible penalty for that offense is also up to 1 year.
Yes, sir.
Do you understand that you have a right to contest this violation of probation charge and have a trial on it?
Yes, sir.
You understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, sir.
You have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have in the order any witnesses you have for your defense to appear at your trial. You understand all of that?
Yes, sir.
You are not required to testify at your trial. Nobody can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, sir.
On the other hand, you also have the right to testify if you wanted to testify. Do you understand that as well?
Yes, sir.
Okay.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial?
Yes, sir.
As I've already explained.
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Has anybody threatened you in any way in order to get you to plead guilty?
No, sir.
If I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
So you were previously placed on probation in these matters sometime around September 2023. Is that right?
Yes, sir.
And in the 24 case, it would have been more like, let's see, that was in June of 2024. Is that correct?
Yes, sir.
And in both of those cases, you were placed on probation. Is that right?
Yes, sir.
And your probation had requirements that you drug test as directed by your probation officer.
Yes, sir.
And there come a time in July that you failed to do your drug testing?
Yes, sir.
All right, I'll accept your plea. It's been given understandably, voluntarily, and accurately. Mr. Collar's had full knowledge of his rights and he has had competent counsel. I have received a recommendation from Mr. Collar's probation officer. Ms. Underwood, is there anything you'd like to say further before the court passes sentence?
Just that, in the words of Mr. McCarron, Mr. Collar is doing much better, Your Honor. And that's the reason for the recommendation. We would ask the court to follow it today.
Mr. Collar, is there anything you'd like to say on your own behalf before the court passes sentence?
No, thank you, sir.
Okay, I had a chance to review both files as well as the recommendation provided by Mr. McCarron. It does appear from that recommendation that Mr. Collar is in a much better place with respect to his substance use issues at this point. It's also clear from the recommendation that although we've reached the end of the probation in these cases, Mr. Collar is still on probation in some other cases with Mr. McCarron and will remain so. Given those things, I do think that the appropriate sentence is consistent with what's been recommended, and that's that probation in these two cases be terminated this time, and that Mr. Collar continue on probation in the other active cases with Mr. McCarron. So that would be the sentence. Mr. Collar, I'm going to ask you to wait in the gallery for just a few minutes. We're going to have some forms for you to sign. They are your notice of appellate rights forms. You're going to get 3 copies of those forms in each file. You're going to need to sign 1 copy for each file that indicates you got your copies and give those back to us. The remaining portion of the file, if you want to request an appeal of your sentence, you would need to fill out the remaining portion of that form and mail it to the address listed in that form within 42 days. Do you understand?
Yes, sir.
Okay. So once you get those and you've signed your copies and returned, you're free to go.
All right, thank you.
Thank you. Okay, Ms. Hanson-Grimes, are you ready to proceed with Ms. Cooper?
Yes, Your Honor.
And do we want to call Ms. Cooper and Mr. Cooper's cases together? Or how do you want?
Yes, Your Honor.
All right, Ms. White, are you there?
Yes, Your Honor, I'm here. I'm turning on my video.
Okay. Okay, just making sure before we get started. So, all right, this is file 24-22084-FC, 25-22161-FH, People versus Eric Lee Cooper. Also file 25-22162-FH, People versus Megan Marie Cooper. First, can I have the attorneys place their appearances on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
And good morning, Your Honor. May it please the Sergeant White appearing on behalf of Mr. Cooper with co-counsel. I'm sorry, go ahead.
Attorney Ashley Hanson Grimes on behalf of Megan Cooper. Do you also have another 25 file for Mr. Cooper with Mr. Brian Fry beyond that?
I have a 24 file that Ms. White is on. The 25 file, yes, Mr. Fry is on.
I didn't know if you wanted to, if he's on your Zoom or not, Your Honor.
Yeah, he is.
Good morning, Your Honor. Brian Fry, appearing for Eric Cooper. On the newest file.
All right, and so I don't know who wants to start, but where do we stand with these three cases today?
Judge, I can start real quickly on Mr. Cooper's. So this was remanded for preliminary exam because I had added counts to amended informations for both Megan Cooper and Eric Cooper. As to Megan Cooper, at this time, we are not going to proceed on that count I added, and then I've already nollied it in circuit court. So with her, we're not going to proceed on that count at this time. We may at a later date, but we canceled the preliminary exam and had that come back to circuit court. With Eric Cooper, Ms. White and I had a discussion, and she agreed to not have a preliminary exam. So I had an amended information in which we had charged account 15, delivery of controlled substance causing death. There was another delivery of fentanyl that it really was sort of more related to Mr. Fry's case, but we agreed to add that to Eric Cooper's case where Ms. White represents him. So we do have a third amended information that has added those two counts that we had remanded for exam on, or I charged him in district court. Anyways, they were in district court for exam, but we've agreed to add those counts. So we do have a third amended felony information. So I'd ask defense counsel to acknowledge receipt of that and to confirm our agreement to allow filing of that third amended felony information.
So stipulated, Your Honor. And in addition to that, Your Honor, I received an offer from the prosecutor on Monday, and I immediately contacted my client, presented the offer to Mr. Cooper, and Mr. Cooper has rejected the offer. I would ask if the prosecutor would place that offer on the record, and I would like if the court would allow the opportunity to voir dire Mr. Cooper regarding the offer that was presented.
Okay, Ms. Arnold, do you want to state the terms of that offer, please?
Yeah, I want to put it on the record. Hang on, I didn't know I was going to do this. I want to put on the record what I sent an email regarding it. Hang on a second. I want to put it on the record what the sentencing guidelines are. And I need to pull up my email. It's really confusing because of the number of files and the number of counts and what's consecutive and all that. So I'm going to send that. Okay. Here we go. So I offered Mr. Cooper a plea to the delivery causing death count only with the habitual offender supplements. I would not care if that was a guilty or a no contest plea. An agreement of 15 years in prison on the minimum on that one count only. That would resolve all the pending files, including Mr. Fry's file. So just so he understands, the possession with intent to deliver charge of 450 grams up to 1,000 grams, my guideline scoring is 126 to 420 months on the minimum on that count. And it is our position, Ms. White does have this video that Mr. Cooper confessed to that particular offense. So the guidelines on that offense are 126 to 420 months. He also has a felony firearm charge, possessed several weapons, which could add 2 years to the minimum on that. So if he's convicted just on that count, at a minimum, under guidelines, he would face 12 and a half years up to 420 months plus 2 years, whatever that is, 30 some years, I think. The February charges, he's charged with a possession with intent to deliver count and also a delivery count from February after this November incident. Those two charges, if he's convicted of those, could be stacked with each other and are also mandatory consecutive to the possession with intent to deliver 450 up to 1,000 grams. So those could add several years to that. If he's also convicted of the delivery causing death case, the delivery causing death or any other felony other than the felony firearm, because he has felon in possession of firearm, I think felon in possession of ammunition, those could all be stacked with the PWID possession with intent to deliver 450 up to 1,000 grams. So his exposure, his total exposure is something like 126 to 420 months, potentially stacked with 126 to 420 months, plus 2 years for the felony firearms, plus any conviction from February. The February incidents would have to be mandatory consecutive. So his potential exposure is, you know, the rest of his life in essence. So I just wanted, and it could be way in excess of that 15 years, even if he's not convicted of the delivery causing death count. So I wanted to put that all on the record. I know Ms. White and I have discussed this previously, and I'm sure she has discussed this with him, but we want to make sure he fully understands that before he rejects the plea offer.
Mr. Cooper, have I presented the offer to you previously?
Yes, ma'am.
And did you reject the offer at that time?
Yes.
Do me a favor, Mr. Cooper. Remove your hat. We're in court. Thank you so much. I appreciate you. And did you hear the prosecutor place the offer on the record?
Yep.
And are you rejecting it at this time?
Yes.
Okay. And to your credit, the offer was made roughly 48 hours ago. Can we agree with that?
Yep.
Okay. Would you like a little bit more time to consider it? It's a lot going on.
No, I would just like the discovery.
Okay. Understood. Not a problem. Okay. Judge, there is one issue regarding I guess the delivery causing death case. And we need the protocol for the delivery causing death case, the autopsy, to move forward on that particular case.
Judge, that I believe that's already been sent, but there's quite a bit of discovery. I will make sure that Ms. White has that, but I believe that was previously sent.
Yeah, I don't have that, Ms. Arnold. If you could send, I would be so greatly appreciated because the discovery is voluminous. And if you could send that separately so that it doesn't get mixed up with all the other discovery, I would appreciate it.
I'll email it to you this morning. If you don't get it for some reason, send me a text and let me know, but I'll email the autopsy plus the accompanying toxicology this morning.
Thank you so much. Thank you. And
the only other potential discovery matter is there were some phones that were dumped, and I don't have copies of the phone dumps myself because they're so excessive they need to be placed on a hard drive. So I have asked Miss White and Miss Hanson Grimes, and I guess Mr. Fry, if he wants them too, to give us a hard drive and we can copy those phone dumps onto the hard drive.
Thank you so much. I've already spoken with co-counsel regarding that, and we're prepared to do that. There's one other issue. Mr. Cooper has indicated that he just wants the discovery, but Mr. Cooper, and I want the record to reflect, regarding the discovery that I am in possession of, you have been, in fact, to my office, and you have sat across a desk from me, and we have gone over your case as well as the discovery. In addition to that, I have made an attorney visit in person to the county jail with your discovery, and we have gone over it in your presence. Is that fair?
Yes, ma'am.
Okay, thank you, sir.
And Your Honor, as it relates to Megan Cooper, and just to piggyback on what Ms. Arnold said, is I do intend to go tomorrow with a flash drive to her office and download all of the discovery as it relates to all files. So that will further assist me in representing my clients. And at this point,
Just wait, hang on one second. I don't mean to interrupt, but one, it needs to be a hard drive, not a flash drive. Flash drives are not, we need like a 3 terabyte hard drive. And the I do not have the phone dumps here. They're at the they're with the state police, so you'll have to drop it off and give us a day or two turnaround time to get that stuff copied. It takes several hours to put those phone dumps onto a hard drive. It doesn't happen instantaneously. So just so you know.
can you get the exact specifications as to what they need? Can you get that emailed to me so I can procure that and get that to you?
Yeah, I think a 3 terabyte hard drive. But yeah, I'll send you that.
I'll be honest, I don't know what a hard drive is. Like, in my head, like there's flash drives, there's like little things like.
Yeah, this is the next step up. So they make portable hard drives.
I'll ask my kids.
Yeah.
Like, I don't know.
Yeah, there you go.
So with that being said, I think obviously there's still discovery out here lingering. We're still in the early stages, as we all thought that there was going to perhaps be preliminary exams held last week. As it relates to Ms. Cooper, they were not. As it relates to Mr. Cooper, they were not. We had scheduled this date thinking that maybe things would have been a little further along or that circumstances may have changed. I'm asking again that we go into the first of the year, perhaps January 7th, Your Honor, at which time it sounds like we should have everything. And if we don't, appropriate motions could be filed to procure maybe what is still lingering out there. I know that Ms. Arnold and I had talked previously about phone records, and then there had been an issue as to whether a dump was requested, and then it turns out it wasn't, and then that needed to be done. So procedurally, we're just kind of at the mercy of others in procuring information so that we can really make an informed decision. As the court is well aware, we're talking many months and many years and in a decision that can't be made within 48 hours for anyone. So if the court is okay with that, and if other councils, brother and sister council would be agreeable to having us come back on January 7th, we can see where things are at that time and maybe move this case a little further in a direction. We're further along than we were the last time we were here, but we're not where we need to be yet to make any hard and fast decisions.
All right, Mr. Fry, is there anything that you need to add on your file?
Your Honor, I think there's extensive discovery in this case, as has been discussed. Mr. Cooper is obviously facing very serious charges and, quite a few charges. So I think time is just needed to go through all this. So I would concur that an adjournment would be appropriate at this time.
And Judge, I should place on the record too that there were 2 phones taken when the February search warrant was executed. And we have not done an extraction on those phones. We kind of weren't planning to, but if the defense attorneys request an extraction of those phones, I can let MSP know and get that process underway.
Your Honor, I mean, to that, if I may respond, then give me back the phones and I'll get my own information off there.
Right. Well, that's what I'm wondering. If they want an extraction, we can have that performed.
I just want property back. I'd like the property back. I would like the 2 phones taken in February back if there has not been an extraction done yet and there was not an intention to do so.
Yeah, that's fine. I'll talk to MSP about that. We'll probably have an extraction performed. But I'll talk to them about that, and I'll let defense counsel know soon on that.
Okay, thank you.
All right, so is there any issue with the January 7th date then?
No, Your Honor.
That works for me.
That works, Your Honor.
Okay. All right, so I understand that there is voluminous discovery in this case. It sounds like we're on a path forward to get that all exchanged. I do hope that everything that needs to be exchanged will be exchanged by January 7th, because these are aging cases. I understand the reasons for that, but when they start to get this old, I feel the need to start to make sure things are moving along at a brisk pace. The court has some scheduling challenges for pretty much all of next year at this point. And so scheduling a trial in a matter as serious as this is going to be a ways out. So I would anticipate, given those circumstances and given the fact that we're probably looking at realistically June or July, maybe even September, for the court to find a period of time for to conduct these trials. I would be looking at having discussions about scheduling trials at the January 7th pre-trial, again with the understanding that you're going to have a significant amount of lag time between January 7th and whatever trial date we would be able to come up with.
Thank you. Thank you for that information and the disclosure by the court, Your Honor. Knowing how heavy your docket is does help us move things forward.
Thank you, Your Honor.
Is there anything else we need to address on any of the files today?
Nothing further, Your Honor.
No, thanks, Judge.
Not at this time.
Okay. All right, thank you then. Those here by Zoom are free to log out, and Ms. Hanscom is free to go.
Thank you, Your Honor.
Thank you.
Thank you.
Okay, Ms. Underwood, if you need to go to Judge Angelo's court, you can go ahead.
Thank you.
That's Mr. No. Okay, Mr. Noe, are you ready to proceed with Mr. Maples?
I certainly am.
Okay. All right, this is file 23-21397-FC, People versus Stephen Maples. We are here today for a pretrial hearing in this case. We are proceeding today by video conference. First, may I have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the People.
Good morning, Honor. Charles Noe on behalf of Mr. Maples.
Okay, and Mr. Noe, where do we stand with Mr. Maples' case today?
Thank you, Your Honor. Thank you. I want to update the court regarding the status of the forensic evaluation. Over the past several weeks, as the court instructed me, I made repeated attempts to contact my expert witness by both phone and email, but have not received any response. So obviously recognizing my own frustration and the court's frustration, particularly with trial scheduled to go on April 13th, I certainly share the concern regarding the delay. So to address that, I obviously am sending back a formal letter to my former expert that we were going to use. requesting immediate communication, confirmation of payment, and a projected timeline. In addition, though, given that lack of response, I've already reached out to another qualified expert to initiate the process of securing an alternative evaluation, should that become necessary. My intention is clear, is to ensure this case continues to move forward and Mr. Maples' evaluation, if what's going to be done, is completed in time for trial, and especially in advance, to give the people time to do the to experts review it as well. Judge, I am taking all reasonable steps to avoid further delays. I'll update Ms. Arnold as soon as I receive information from either evaluator. If the court has a preferred course of action or would like me to take additional steps, as it advised me previously, I am prepared to follow the court's direction. At this time, my recommendation would be to set another pretrial on this matter in approximately 30 days out to keep our thumb on the situation and make sure that this case proceeds and progresses the way I want it to and the court wants it to, and most importantly, so for my client's rights as well. But that's where we stand today, Judge.
All right, Ms. Arnold, is there anything we need?
My suggestion would be, I guess what I would suggest is, what if we set a pretrial in 2 weeks and Mr. Noe just subpoenas the expert to show up at pretrial? It would get, him in a discussion with the expert at least. They could have a, breakout session or whatever. But I think 30 days, I guess if that's what we have to do, that's what we have to do. I just want to make sure that whatever report I get, that I have plenty of time to have it reviewed by somebody, and, have my own expert be able to designate that expert and list that expert on any witness list more than 28 days before the trial dates. So that means I have to list an expert in March, the beginning of March. So I just want to make sure I have time to do that. Middle March.
It's fine. Ultimately, the only issue is that I believe the subpoena, I don't know if 2 weeks would be enough time for serving that to even make sure that Dr. Mayman appeared under the court rules. But that'd be my only concern regarding that. I don't necessarily hate that idea. I just don't know if that is enough time under the court rules to ensure appearance. But I certainly don't hate that idea.
Okay. Yeah, I'm not here in 2 weeks anyway, so that wouldn't work. The next available date that I have is actually December 17th. So unless I might be able to squeeze one more in the week before. Let me look at that.
There.
Yeah, so it's going to have to be the 17th.
Yeah, I think if Mr. Noe sends his expert a subpoena for December 17th, I would imagine he'll get some communication from the expert. And I know we've had this issue in other cases that these experts are just seem to be difficult to work with. I don't know why it is, but.
All right, so we'll adjourn this to December 17th at 8:15. Mr. Noe, would you do that stipulation in order?
I will, and may I sign that with your permission, Ms. Arnold?
Sure.
All right, is there anything else we need to address today?
No, I saw my client raise his hand. I don't know if I certainly don't want to say anything in court, but is there something you want to talk to me more about, Mr. Maples?
Yes, if we could have a moment.
Yeah, if I can have a brief breakout with my client.
Yeah, 1 second. Mr. Feifelsky, are you ready to proceed with Mr. Federer?
I am. My client was just here.
Oh, I'm sorry.
Right out of college. Right. He's right here, Your Honor, so we're ready.
Okay.
Give me your eye, go to the head.
No problem.
Good morning, Your Honor.
Good morning. All right, this is file 25-22422-FH and 25-22423-FH. Bull versus Jeffrey Allen Federer. We are here today for pretrial conferences in both of those cases, and we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto.
And good morning, Your Honor. James Feifelsky appearing with and on behalf of Mr. Federer. Can you state your name, please?
Jeffrey Allen Federer, Your Honor.
Okay, and Mr. Feifelsky, where do we stand with Mr. Federer's case today?
Your Honor, Mr. Bayoneto and I have reached a plea agreement, and that is in writing and signed by counsel and Mr. Federer. I have submitted a request for a Cobb's evaluation in this case. I know it did come in just yesterday, so if the court needed more time. But I think there are some compelling circumstances that I would ask the court to consider before entry of the plea, if the court is comfortable with that. And specifically, my request would be that the court enter a Cobb's agreement to sentence my client to the minimum mandatory under the statute, which is the 30 days. I would be requesting weekends. I have discussed Veterans Court with my client. He tells me it would be very difficult because he doesn't have a license and he lives alone. He doesn't have reliable transportation. So getting to the court and probation as frequently as he would need to would be almost impossible. He has been engaging in significant treatment, as I laid out in the proposal, and continues to do aftercare. It's probably by Zoom. It's a therapy treatment. Is that correct?
Yes, yes.
And daily testing. And certainly, given Mr. Federer's life circumstances right now, I think as a 100% disabled vet, he has time to help people. And so stacking him with hours and days of community service would certainly be one way to also give him an opportunity to continue to give back. Because he was sober for quite a while since his last offense, I think about 7 years. And the problem was, I should say that the important insight 7 years ago was that he discovered he needed to take medication, psychotropics. He was taking that medication for the last 7 years, felt at some point earlier this year, which was a mistake. He now realizes that he would be okay without it. And that's ultimately why he relapsed. Since realizing that mental health treatment and sobriety go hand in hand for him. He cannot have one without the other. He took the bull by the horns and he went inpatient 120 days. He's been doing really well. There's a lot of other things. I put them in the proposal. I don't want to take too much of the court's time, but that would be the substance of my request for the court to consider is the minimum 30 days with weekends and as much community service and other conditions the court sees fit, as well as continue him on the sober link. He's been doing that well. That's something he'd be happy to keep on for the duration of probation from what he tells me. Otherwise, I think he has been a very good contributing member of his community and wants to continue to do that.
All right, Mr. Bayonet, anything you would like to address with respect to that issue?
Your Honor, I have no position. I'll defer to the court's discretion in any decision as it relates to the requested Cobb's agreement.
Okay. I did have a chance to read the memorandum that you filed, Mr. Feifelsky, and obviously listen to your argument here today. At this point, I am not willing to give a Cobb's evaluation under these circumstances. I understand that Mr. Federer has, the things that you have outlined that would be in his favor as mitigating circumstances. I also, when I look at these files, this would be the 8th drinking and driving conviction with a 9th one that's being dismissed. And so I think under those circumstances, I owe it to the community to thoroughly review the pre-sentence investigation report and be familiar with all of the circumstances surrounding Mr. Federer before I make any decision on or any commitment with respect to a sentence. That would be my position at this point.
Okay. That said, Mr. Federer, are you prepared to move forward with the plea without knowing what the sentence may be? And we can talk about this more if we need more time.
If you need a moment to think or a moment to talk, or you don't have to make that decision right now.
Yes, sir. Would like to say something, if I'm allowed, just for a couple minutes.
Well, the judge is telling us right now that he's not making a Cobb's agreement. So I think the best thing, and I know my client does want to speak directly to the court. I'm sorry to cut him off. And if the court wants to hear from him, I completely appreciate that. But I also understand the protocol that we have here. So
I don't necessarily mind hearing from people directly, but the thing is, he hasn't entered a plea yet, and I don't know where this is going to go, and I wouldn't want him to say anything that would compromise any of his rights. And so what I'm saying is, I'm not. It's not that I'm not going to consider or not do ultimately what is in the proposal. I may do that, but I'm not willing to commit to it right now. Because, for the reasons that I said, I think it's important for me under these circumstances to have a full understanding and know what the full picture is before I make any decisions.
That's kind of what I wanted to say, to get the full picture, Your Honor. It's just 1 minute to explain the reason why for the PTSD was
okay,
all
so
those.
I appreciate that. I appreciate that, but the full picture is not just what comes from you.
Yes,
so
sir.
even if I let you speak and listen to you and hear you out, my answer is going to be the same.
Yes, sir.
For today's purposes.
Yes, sir.
Because if there's a plea, if there's a conviction, there will be a pre-sentence investigation report that will go into a lot of details about your life.
Yes, sir.
Go into details about what has happened in terms of the circumstance of these incidents. And I want to know all that information before I make any kind of decision in either direction.
Yes, sir.
That said, Your Honor, would the court consider, because this is our first pretrial, I think maybe the best thing is to, or I would like to request one more pretrial before the pleas are entered, so that at the very least I can have a little more of a conversation with Mr. Bayonetto and with my client more specifically about proceeding. I think it's likely we'll continue the resolution we have in place. I just would like a little more time.
That's fine. I understand you've received some new information here today, and I don't want people to make snap decisions either. So
Thank you, Your Honor.
we can adjourn this to it's going to be January 7th at 8:15.
Okay, that's fine with me. That works for you, right?
I think I got a VA dental appointment on the 7th, so I think, but I'll just cancel it and move it. This takes precedence.
Okay. And you're welcome to attend that by Zoom if you have transportation issues or can't be here.
Okay.
Whatever it is.
Thank you very much, Your Honor.
Thank you for that, Your Honor. Thank you.
Bailiff can give you our Zoom information if you don't have it already.
Yes, sir.
Okay.
Thank you for your time, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Good day.
All right, Mr. Noe, was there anything else we need to address in Mr. Maples' case?
No, there's nothing further. I didn't want to log off without checking with you first, though.
Okay, no problem.
Thanks again, Your Honor.
Mr. Maples, you can let the officer with you know that you're done with court for today. I'm sorry, Mr. Hall, what case are you here for?
Good morning, Your Honor. I'm here for defendant Kaida Matson, Matson.
Okay.
Thank you.
I'm just bringing her into the meeting now. All right, this is file 25-22456-FH, People versus Kaida Joe Matson. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Ms. Matson, who appears via Zoom without objection to appearing in that manner today for arraignment.
All right, and Miss, you are Kaida Joe Matson?
Yes, Your Honor.
Mr. Hall, have you received, does Ms. Matson wish to have the information read?
We do not, Your Honor. We'd waive formal reading and stand mute at this time.
All right, I will then enter a not guilty plea for Ms. Matson, and we can set a pretrial conference for, let's go with January 14th at 8:15 a.m.
Your Honor, that is a perfect date. I've spoken with Mr. Sneed already. There's an ongoing case of a similar nature in Washtenaw County. He understands, and we've spoken about essentially coordinating those cases so that Ms. Matson can make decisions in a fully advised manner. So that date works perfect for our calendar.
Okay. Anything else we need to address today, Mr. Sneed?
No, thank you, Your Honor.
And Kaida, you're now out of the hospital. You're at home.
I am.
Okay, so you're picking up the colors then.
Yes.
Okay.
And Your Honor, one thing I'd like to get ahead of, if possible, I am going to counsel Ms. Matson regarding the Lenawee County Recovery Court, not currently knowing whether that's a possibility to be contemplated in this case. It's something I'd like to discuss with her. And Mr. Sneed, if there's any way I can get out ahead of that as far as screening and eligibility, I can start that certainly ahead of the next court date.
Mm-hmm.
Thank you.
Thank you.
Mhm.
Okay, so Ms. Mattson, your next date in this court will be January 14th at 8:15 a.m. You can log in using all the same Zoom information that you used today.
Okay, thank you, Your Honor.
Thanks again, Your Honor. Take care, everybody.
Okay, Ms. Underwood, Mr. Skinner is here in person. Do you need to speak to him?
Yes, please.
Okay, Mr. Skinner, if you could step outside to the iPad, we'll put you in a breakout session.
And coming from you is you just is you know, a professional saying that. This.
Okay, 1 second.
About the PTSD prior to 2017 is what likely contributed.
I call that Mike, guy that wrote that over there.
Step outside and tell Mr. Feifelsky he's too close to the iPad and keep doing this conversation. Did one of you have a case?
Watson?
Watson, okay. Okay, Mr. Fry, I have Mr. Watson Clark here in the courtroom. Do you need to speak to him?
If I could, Your Honor, that might be helpful.
Okay, as soon as Mr. Skinner's done on the iPad, I'll have you go outside and I'll put you in a breakout session with Mr. Fry. No, Phoebe wanted, they have a hearing at 11. We're just gonna wait till.
Okay.
Okay, Mr. Murphy, I do have Mr. Rutledge here. Are you gonna need to speak to him?
If I could, please, Your Honor, briefly.
Okay, Mr. Rutledge, if you're there, I've sent you a request to start your video. And I'll need you to unmute your device. Okay, I'm going to put you in a breakout session with Mr. Murphy. Judge, would you like me to come up here? Yeah, that's fine. Is file 24-22029-FH and 24-22031-FH. People versus Patrick Lee Skinner. We are here today for a hearing on probation violations in each of those cases. And we are proceeding today by partially in person, partially by video conference. Ms. Underwood, would you like to place your appearance on the record?
Yes, Your Honor. Rhonda Underwood. I don't believe I've been appointed on these yet, Your Honor. This was a request and warrant show cause, I believe, that Mr. Skinner's.
Sorry. Yeah, I apologize. These are new.
I do have the documents though, Your Honor,
All right.
and have discussed them with Mr. Skinner.
All right. And I'm sorry, sir, you are Patrick Lee Skinner, correct? Yes, sir. Mr. Skinner, have you received copies of the request and summons for probation violation in each file? Yes, sir. That summons for probation violation alleges that you violated the terms of your probation by failing to submit to drug screens on October 15, 17, 20, 23, 28, and 31st of 2025. You failed to obtain a substance abuse assessment on October 31, 2025, as instructed. In file 24-22031-FH, you had pled guilty to possession of methamphetamine. The maximum possible punishment for that offense is up to 10 years in prison and or a $15,000 fine. In file 24-22029-FH, you have pled guilty to larceny in a building, and the maximum possible punishment for that offense is up to 4 years in prison. You do have the right to be represented by an attorney at this hearing and at any other hearings that we have regarding this matter. If you can't afford an attorney, you can tell me one. I'll appoint one for you from the public defender's office. I've already spoken to Ms. Underwood on this. Do you want her to represent you on this? Yes, sir. Do you have the financial ability to pay for your own attorney? No, sir. All right. I will appoint the public defender's office to represent you on these probation violations. Ms. Underwood, now would you like to place your appearance on the record?
Rhonda Underwood for Mr. Skinner this morning, Your Honor. I've discussed this matter with Mr. Skinner. We would ask for an adjournment for a pretrial in this matter, Your Honor. I believe Mr. Skinner has proof of that he was in rehab for at least part of this time, Your Honor. So I know he would like to present that to Mr. Stevenson. So we would ask for a not guilty plea and that this matter be adjourned for a couple weeks.
I will enter a not guilty plea for Mr. Skinner in both files. I'll set this for a pretrial on December 17th at 8:15 a.m.
Thank you, Your Honor.
No, Mr. Skinner, if you want to attend that by Zoom, you can attend by Zoom. You just need to be sure that you're in a place that has adequate bandwidth and the, the Zoom is going to go all right.
I'd also like to force you aware that I just got my VA compensation approved. So I got VA healthcare and everything, and I'm meeting with my probation officer Jackson today for actual VA treatment center to send me to, because Harbor Lake, the reason I left early is that my insurance wouldn't cover it because it's just went away to Jackson County. So my Medicaid wouldn't cover Harbor Lake, and that's why I left. There per my PO's instructions to be in treatment by the end of the week, and I guess she forgot that I was supposed to be in treatment and then put me down as a misreport date.
Okay.
Judge?
Yeah.
Your Honor, can you have him report to our lobby, please, in the probation department?
Yeah. All right. So if you'll just step across the hall, the probation office, Mr. Stevenson can talk to you now.
Thank you.
All right, Mr. Fry, you ready to proceed with Mr. Watson Clark?
Yes, Your Honor.
Okay, this is file 25-22230-FH, People versus Anthony Wayne Watson Clark. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayonet.
Alex Bayoneto for the people.
Brian Fry, attorney for the defendant.
And sir, you're Anthony Wayne Watson Clark.
Yes, Your Honor.
All right, Mr. Fry, where do we stand with Mr. Watson Clark's case today?
Yeah, Your Honor, my client is working through the diversion program. I think he's completed the class, and but he still is trying to make the payments on that. He's had some medical issues the past month and a half that has prevented him from working, and he still has another month before he's going to be cleared to go back to work due to some surgery he just had. So it's going to take him a little bit of time to finish the diversion program and complete the payments. So we'd be asking for an adjournment of a few months, maybe in February or so.
Mr. Bayonet.
Your Honor, I'm looking through Mr. Went's notes. Mr. Watson Clark has made some payments. There's still a few $1,000s that's outstanding in restitution. So I think a few months is appropriate. The only thing I'd ask is that the defendant be instructed to contact Mr. Went today, just so they can get back on the same page and figure out the payments and Mr. Watson Clark's work schedule going forward.
Okay, so I'll adjourn this to February 11th at 8:15 a.m. And Mr. Watson Clark, if you prefer to attend that by Zoom, you can do that. Our bailiff can give you our Zoom information. That you contact Mr. Went either today or tomorrow. We'll get in touch with him, make sure that he knows what your situation is. Get back, move forward when you're physically able.
Sounds good.
Okay.
All right, appreciate it.
You were all set for today.
All right, have a good day.
Thank you.
Thank you. Your Honor, did you want me to prepare that adjournment? And if so, Mr. Bayoneto, could I sign your name to that?
You can, yes. Thank you.
Thank you.
Yes, thank you for the reminder, Mr. Fry. Oh. Zachary Franklin. Okay, Mr. Murphy, are you ready to proceed with Mr. Rutledge?
Yes, Your Honor.
Okay, we'll do that in just a moment. Mr. Fry, I don't have Mr. Rohrback here. I don't know if you have had any communication with him. I want to try to.
I did talk to him earlier today. He indicated he was on Zoom, Your Honor. If you don't see him on there, I can try to reach back out to him.
Yeah, no, I haven't seen him in the waiting room yet this morning. That doesn't mean he's popped in and out, but I haven't seen him.
I'll double check. Maybe he went to the wrong room or something.
Okay.
Thanks.
Okay, this is file 25-22275-FH. People versus Lucas Allen Rutledge. We are here today for a final pretrial conference in this case. We are proceeding today by video conference. First, can I have the attorneys place their appearance on record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy appearing on behalf of Mr. Rutledge, who's appearing today via Zoom.
Okay, and Mr. Murphy, where do we stand with Mr. Rutledge's case today?
Your Honor, there is a plea agreement that Mr. Sneed extended to Mr. Rutledge for Mr. Rutledge to plead to count 2, malicious destruction of property or destruction of a building, 1,000 to 20,000, and an added count 3 of an attempted breaking and entering with intent, dismissal of count 1, the breaking and entering with intent, the full charge, as well as the habitual offender, 4th offense notice on the counts. Further, Mr. Sneed would do a sentencing agreement to 1 year in the Lenawee County Jail suspended and 3 years of probation, stipulating that if the defendant were to violate his bond conditions in any way prior to sentencing or materially violate his probation, he would be expected to serve that 1 year in jail with any credit for time that he served to that date. And also that Mr. Rutledge would agree to stipulate to an order for wage assignment, which shall be applied to the restitution in this matter prior to any application to the fines and costs. The plea agreement had the restitution at $4,461. I wasn't sure, Mr. Sneed, was that before or after we talked about that, the popcorn machine? I forgot.
That's in consideration of taking the popcorn machine off of the restitution amount. So that's reduced from what we had previously discussed.
Okay. So at this point, again, I had discussed it with my client. My understanding is he did wish to accept that offer and again enter a plea of guilty to count 2, destruction of a building, 1,000 to 20,000, and an added count 3 of attempted breaking and entering with intent.
Hey.
I'm sorry, Mr. Rutledge, did you say you wanted to speak to me?
Oh, no.
Oh, okay. I'm sorry. I thought I heard something.
Okay. All right. So I don't have a signed advice of rights form or an amend. You said there was an amended with a count 3.
Yes, Your Honor. That's my an added count 3. I just sent over the signed plea agreement and the advice of rights, or I just asked my assistant to do that 5 minutes ago or so. I thought we had received an amended information.
Your Honor, sorry.
I'm sorry. So I have an amended information, but it only has 2 counts on.
Yeah, we'll need to fix that, Judge. Apologize.
Okay.
Your Honor, if he's available, could I have a breakout with Mr. Kranker?
Yeah, I'm trying to do that right now. Mr. Cranker, are you there? Can you call the jail again? I don't know what happened, Mr. Cranker.
Hi, County Judge Officers. We lost Mr. Krieger. Is that in the jail room? Thank you. Bye.
Mr. Murphy, while we're waiting, I have not seen Mr. West at any point today. Have you had any communication with him?
Unfortunately, I have not, Your Honor. It's been some time since I've been able to connect with him.
All right, let me call those then. This is file 25. 25-22294-FH and 20-20069-FH. People versus Wendell Charles West. We are here today for a pretrial conference in the 25 case and a show cause hearing in the 20 case. Court is open to the public proceeding in person and also by video conference. First, can I have the attorneys place their appearances on record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy, appearing on behalf of Mr. West.
Okay, and the record should reflect this matter was set for hearing this morning at 8:15 a.m. It's now 9:50 a.m. Mr. West is not present in the courtroom in person, nor is he logged into the Zoom session. He's not been logged into the Zoom session or here in person at any point this morning. Mr. Murphy, is there anything you'd like to say with respect to Mr. West?
Your Honor, again, it's been some time since I've been able to connect with Mr. West and talk about the case. I believe it was shortly after the last pretrial was the last conversation that we had. So I do apologize for that, Your Honor. I understand that there was a show cause. We received information on that or received documentation on that. Because of this situation, I know there's a jury trial scheduled. There was already going to be a conflict with another older file that I had with a client that's in custody right now with a 5-day trial scheduled for overlapping on Mr. West's trial. So I was already going to probably be requesting that we remove the jury trial date. But especially since I haven't been able to speak with him, I haven't really been able to prepare much, nor try to figure out if we can resolve it short of the trial. So given the fact that I haven't been able to speak with him and his lack of appearance here, obviously I guess I'll defer to the court with what you want to do in regards to issuing a bench warrant or not, or giving him a hold or not. But I would ask the court to consider removing the jury trial date and just saying that as another pretrial, hoping that we can, again, speak to Mr. West and get the case moving along. So I do apologize for his absence, Your Honor.
All right, Mr. Sneed, anything that you would like to address?
Your Honor, the people would request a bench warrant to issue, and I have no objection to the court removing the trial date from the docket, which is set for December 4th, and scheduling a pretrial at the court's discretion.
Okay, so obviously the 20 case is quite old. Mr. West had failed to appear back in February of 2021 and was not seen again by the court until May of 2025. So we had that one pending with prior failure to appear. He's failed to appear here today at the final pretrial ahead of a trial that was scheduled for, I believe, December 4th. Yeah, December 4th. Making it impossible to proceed. So I am going to issue a bench warrant for his arrest. I'm going to set bond on the bench warrant in the amount of $25,000 cash in each file.
Yes, Your Honor. Sorry, yeah, we will vacate the trial date scheduled for December 4th. Thank you, Your Honor. Okay, Mr. Malero, do you need to speak to Mr. Whiteman?
Yes, Judge.
All right, Mr. Whiteman, if you're there, I need you to unmute your device, please. And your request to unmute? You don't seem to be unmuted. Okay.
Yep.
There we go.
Okay, thank you.
Okay, I am going to put you in a breakout session with Mr. Malero.
All righty.
All right, this file.
I'm sorry, Judge, just an FYI, Alan Whiteman's been testing with me. He's done really well. I didn't submit a letter for you, but he is testing.
Okay, thank you. All right, this file 23-21391-FH, People of the State of Michigan versus Zachary Richard Cranker. We are here today for a hearing on a probation violation. We are proceeding today by video conference. First, can you have the attorneys place their appearance on the record? Or I'm sorry, first, can Ms. Underwood place your appearance on the record?
Rhonda Underwood for Mr. Cranker this morning, Your Honor.
All right, and Mr. Cranker is here from the Lenawee County Jail by Zoom. Ms. Underwood, where do we stand with Mr. Cranker's case?
Mr. Cranker and I have went back through it, Your Honor, and Mr. Cranker understands that he made a mistake, and Mr. Cranker is going to plead guilty to the violation today, Your Honor.
All right, Mr. Cranker, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Zachary Richard Cranker, correct?
Yes.
Mr. Cranker, do you understand that you have a right to contest this violation of probation charge and to have a trial on it?
Yes.
Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes.
You'd have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions while they're under oath. And And you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand that?
Yes.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yeah.
On the other hand, do you understand you have a right to testify if you wanted to testify?
Yes.
How do you plead to the charge that you violated your probation by failing to report to serve the remainder of your jail sentence?
Guilty.
You understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Has anybody threatened you in any way in order to get you to plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
So you, in this case, were placed on probation, and that involved a jail sentence. Is that correct?
Yeah.
And you were required to turn yourself in to the Lenawee County Jail after you were released from your incarceration in Ohio to serve the remainder of that sentence. Is that correct?
Apparently, yes. I thought that my paper said once that I was done with my Ohio time, I just had to follow up with probation.
All right, I understand you thought it said something, but you were actually required to submit to the Lenawee County Jail to serve the remainder of a sentence. Is that right?
Yes.
And you didn't in fact do that. Is that correct?
No.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Cranker has had full knowledge of his rights and he has had competent counsel. I will refer this matter to the probation department for an update of Mr. Cranker's pre-sentence investigation. And my next available sentencing date is December 5th at 8:15 a.m.
Thank you, Your Honor.
Obviously, any time between now and then will count toward the remainder of, I think it was, you had 125 days credit toward a 9-month sentence at the time, so he'll have the additional credit between now and December 5th.
Thank you.
All right, Mr. Cranker, you can let the officer with you know that you're done with court for today.
I believe that concludes my docket with you this morning, Your Honor.
Okay, thank you, Ms. Underwood. All right, and I have that amended information now for Mr. Rutledge.
Yes.
And I apologize. Well, I should have it. No. Did we ever get the plea agreement and advice of rights? Mr. Murphy, who did you email the plea agreement and advice of rights to?
Let me go talk to my assistant and see what she did with that. Hold on.
Okay. All right. In the meantime, then, Mr. Malero, are you ready to proceed with Mr. Whiteman?
Yes, Judge.
Okay. This is file 24-22035-FH and 25-22386-FH, People versus Alan G. White. We are here today for a pretrial conference in both of those files. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonetto?
I have the file ending in 386, Your Honor. Mr. Sneed has the other file.
Okay.
So Alex Bayonetto for the people on the file ending in 386.
Isaac Steen for the file ending in 35FH. Thanks.
And Salvatore Malero handling both files.
Okay, Mr. Valero, where do we stand with Mr. Whiteman's cases today?
Your Honor, I'm going to ask for a brief adjournment. Mr. Whiteman has just completed rehab, and then I'd like to corral both prosecutors in one place and maybe find a common resolution.
All right, Mr. Bayonetto, anything we need to address from the people on your file?
No, Your Honor.
Mr. Sneed, anything to address from people on your file?
No, thank you.
All right, because things are getting crowded and we've got holidays coming up, my first available date's going to be January 7th at 8:15.
That's fine with me, Judge.
All right, Mr. Malero, would you do stipulation and orders for both of those files then?
I will, Judge.
All right, so Mr. Whiteman, your next date is January 7th at 8:15 a.m. You can log in using all the same Zoom information that you used today.
Okay, thank you.
Alan, I'll see you Monday, okay?
Alrighty, I'll be there.
Well, correct. Hey, Alan, it's actually Friday.
Friday? Okay.
Yep.
Okay, I do have the plea agreement and advice of rights form now for Mr. Rutledge. Jail for this, of course, yeah. All right, so back on the record in file 25-22275-FH. As I said, I do not have the amended information, the plea agreement, and the signed advice of rights form. So, Mr. Rutledge, would you raise your right hand, sir?
Yes.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury? Mr. Rutledge, are you able to hear me?
Looks like it froze up, Your Honor.
All right, thank you.
Can you hear me now, Mr. Rutledge?
Yes. Now I can hear.
All right, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Lucas Allen Rutledge?
Yes.
Mr. Rutledge, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, malicious destruction of a building, $1,000 or more, but less than $20,000?
Yes.
Do you understand that the maximum possible punishment for that offense is up to 5 years in prison and or a $10,000 fine?
Yes.
Is it also your intention to plead guilty to count 3, attempted breaking and entering a building with intent?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison?
Yes.
Are you satisfied with Mr. Murphy and the advice that he's giving you?
Yes.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court, other than as we've discussed it on the record here today. Is that correct, Mr. Sneed?
Yes, Your Honor.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Rutledge?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. And I'm going to explain those rights to you right now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial. And if the prosecutor and court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have the witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Rutledge, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about November 18, 2024, in Madison Township, Lenawee County, Michigan, that you did commit the offense of malicious destruction of a building, $1,000 or more, but less than $20,000?
Guilty.
And how do you wish to plead to the charge that on or about that same date, again in Madison Township, Lenawee County, Michigan, that you did commit the offense of attempted breaking and entering a building with intent?
Yes. Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your pleas, you're giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the pleas?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than this plea bargain to induce Mr. Rutledge to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Rutledge, has your attorney promised you any particular sentence or estimated what your sentence would be, other than as we've talked about it on the record today?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Murphy, do you want to establish the factual basis?
Yes, Your Honor. Thank you. Mr. Rutledge, were you indeed in Madison Township, the county of Lenawee, state of Michigan, on November 18th last year, 2024?
Yes, I was.
And on that date and time, did you throw a rock through the window of a gas station?
Yes.
And was that gas station located at 1157 West Beecher Road?
Yes.
Do you know who owned the gas station?
I don't.
Would you have any reason to disbelieve that it was a Nicholas Chris was the owner of that gas station?
I believe so, yeah.
Okay. Obviously, though, you did not own that gas station, correct?
No.
And you you broke the window out of the front door and then entered through that front door into that gas station, correct?
Correct.
And you did so with the intent to take some property out, some money out of that store?
Oh, yes.
I'm sorry, was that a yes, Mr. Rutledge? I didn't hear you.
Yes.
And would you agree that the amount of damage done to that front door, with the repairs, the emergency repairs and everything was $4,400.51? Or am I mistaken? Or
Yes.
well, you would agree that it was between 1,000 and 20,000, the value of that, correct?
Yes.
And again, from my understanding, it was $4,461 is what we have for restitution. You would agree that that's correct, Mr. Rutledge?
Yes.
Your Honor, I believe we satisfied the factual basis for both counts for the destruction of the building, for destroying the door, and for breaking and entering or attempted breaking and entering.
Mr. Sneed, are people satisfied with the factual basis?
Judge, thank you.
Okay, has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
Mr. Murphy?
It has, Your Honor, thank you.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Rutledge has had full knowledge of his rights. He's had competent counsel. Looks like we have lost Mr. Rutledge. Give him a moment to see if he reappears. Good morning, Mr. Hartung. Case are you here for?
I have DeJuan Harris with Sam.
Okay. I will open one.
Could we have DeJuan Harris, please? Thank you. Yeah, I can see.
Okay. All right, Mr. Malero, we called the jail for Vanessa Burciaga, and she's apparently in rehab right now. Do you know anything about that?
Yes, Judge, it's she left a message that she will not be getting released by the time of today's pretrial. And I'm not sure if she's in one of the places they don't let you Zoom. I'm not sure. I can look up the note, but she left that message a few days ago. So it's my understanding she is still in rehab.
Can you find out the name of that facility and let Mr. Coase know where she is, please?
Yeah, I'm looking it up right now, Judge.
Okay.
Certain people in my office that I won't name think I can do I can multitask when I cannot.
I think you should turn on your camera and name them.
I will value my freedom, Judge. She's at
Okay.
Sacred Heart, Judge.
Sacred Heart, okay.
She was released on the 29th, and it was confirmed that she is at Sacred Heart.
And Judge, was that a bond condition to where she was to complete that treatment?
I think it was.
This is her first hearing up here. Yes, it was a part of her bond that she was able to go to in-person treatment. That was done on October 2nd.
I'll get a copy of that, Judge, and I'll look into that.
Okay, so we're gonna need to adjourn this, obviously. Let's go with, how about January 7th at 8:15?
That's fine with me, Judge.
And then do you need to speak to Mr. Harris?
I do briefly. And do I need to do the stip on Miss Versiago again?
Yes, please.
All right, thank you.
Okay, Mr. Sneed, Mr. Murphy, we have Mr. Rutledge logged back in. Okay, Mr. Rutledge, if you're there, I'm going to send your request to unmute.
Yes.
Okay,
Sorry.
can you hear me all right, Mr. Rutledge?
Yes, sir. Sorry
Okay.
about that. My phone froze up.
That's okay. I was saying that I will accept your pleas. They have been given understandably, voluntarily, and accurately. You've had full knowledge of your rights and you've had competent counsel. Court hasn't made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for December 19th at 8:15 a.m. Did you hear that date already, Mr. Rutledge?
I'm sorry.
Did you hear that date, Mr. Rutledge?
Yeah, the 19th, December 19th.
Correct, at 8:15 a.m.
Got it.
Someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background, okay?
Your
Okay.
Honor, I'm going to need to speak with him.
Yeah, I'm going to put you, Mr. Rutledge, in a breakout session with Mr. Moore from the probation department. He's going to give you some instructions on what to do next and collect your contact information.
Okay.
Mr. Murphy, did you want to be a part of that?
If I could please, Your Honor, and then I'll just log off from there because I didn't have anything else in your court.
Okay.
Thank you.
Sir Fry, do you have any luck contacting Mr. Rohrbach?
Yes, Your Honor, he's here with me in my office.
He's there. Okay. All right. Okay, this is file 25-22356-FH, 25-22357-FH, and 25-22358-FH. People versus Bradley Dale Rohrbach. We're here for a pretrial conference in each of those cases. The files ending in 356 and 357 also have a pending contempt. And so we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Brian Fry, attorney for Mr. Rohrbach.
All right, Mr. Fry, where do we stand with Mr. Rohrbach's cases today?
Your Honor, I'm going to be asking for an adjournment. I just received word that my client was approved for recovery court. So I want to talk to him about that and the prosecutor as well to see if we can get a resolution on this potentially. But I just need some additional time to have a conversation, mainly with the prosecutor, that I can relate to my client and see if we can get something done. Thank you.
All right, Mr. Sneed, anything we need to address from the people's side?
No, thank you, Your Honor.
Judge, he did get out of jail on 10/29, and I did sign him up for colors. He has yet to make a drug screen. He was a no-show actually just yesterday. So if he does miss again, I will be seeking a contempt on him for not testing.
That's fine, Darren. I told you my wallet was lost.
We'll talk about it.
Thank you. I'm thinking.
All right, Mr. Rohrbach, your ability to be out on bond is contingent upon your doing the testing.
Yes, sir.
And Brad, if you're missing a photo ID, if you want to come to the courthouse, I could do that for you, so you could use that as identification too.
How about tomorrow if I do that, Darren? Can I? Because I don't know when the other one's gonna come. It says 2 weeks, so I've been out.
Well, see me tomorrow morning if you're going to do that.
All right, that'd be great. I appreciate that.
All right, so I'll set this then for January 14th at 8:15 a.m.
That works. Thank you, Your Honor.
Mr. Fry, would you do that stipulation in order?
Yes, I can prepare that. Mr. Sneed, could I sign your name with permission?
Yes, please.
Thank you.
All right, and so then, Mr. Rohrbach, you need to see Mr. Coase tomorrow to get the drug testing sorted out.
Okay, thank you, Judge. Yeah.
I think we're all set on those cases then.
Thank you.
If the jail has a room available to take Matthew May.
So telling the judge, if you have another Zoom available, could we have Matthew May? Yes. Thank you.
Okay, Mr. Valero, are you ready to proceed with Mr. Harris?
I am, Your Honor.
This is file 25-22314-FH and 25-22371-FH, People versus Dewan Pfeiffer Harris. We are here today for pretrials in both of those cases. The 314-FH file also has a pending contempt. We are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Hartman?
Thank you, Your Honor. Good morning. Doug Hartung, appearing for the people today.
Salvatore Malero on behalf of Dewan Harris.
And we do have Mr. Harris here by Zoom from Lenawee County Jail. Mr. Malero, where do we stand with Mr. Harris's cases today?
So judges of the pending cases, Mr. Harris, I'd ask to adjourn those. There's a pending matter down in circuit court that's scheduled for exam on Friday. It's my understanding Mr. Harris wants to go forward on. And then there is the matter, I think today is up for a bond violation hearing. Mr. Harris would like to have that hearing as soon as possible to contest the violation. I have advised Mr. Harris, I think that is a poor decision to make, is against my advice to Mr. Harris with respect to the bond violation. But that he is insistent on having that hearing, so I'd ask the court if it could schedule it as soon as the court can schedule it.
I want to have it today.
All right. Mr. Hartung, is there anything we need to address from the people's side?
I don't believe so.
So you said his preliminary exam on the district court matter is Friday?
Yes, Friday at 1, Judge.
Okay. What I'm going to do is set this then for December 17th at 8:15 a.m. for the pretrials. I'm not here the next 2 Wednesdays, so if that's bound over, the arraignment will be with Judge Anzalone. And if you want to set the pretrials for that same date, you can do that, then we'll have all 3 of them together.
What about the bond violation?
I'm getting to that. Okay, so I presume if we set an hour for that, is that sufficient amount of time? I look to see.
Might be a little more than that. What do you think, Sam?
For the record, I have advised Mr. Harris not to have this bond violation hearing. It's definitely prior to the prelim and definitely prior to the case in chief, but he is insistent against my advice to going forward with it. And I believe there is a U.S. Supreme Court case that mandates that even though I think it's a very bad decision, that I accede to his wishes.
Okay.
So how long it'll take, I have no idea.
If that's the amount of time we're talking about, let's see. Ms. Clark, we just had the trial for the 25th canceled. Do we have any opening on that date?
1:30 on the 25th.
Okay, so we can do 1:30 on the 25th. So Tuesday.
Okay, I can do it.
Are you here, Sam?
I will be here on the 25th.
Okay.
Okay, so we'll set it for November 25th at 1:30 PM. All right, Mr. Harris, then you can let the officer with you know that you are done with work for today, and we'll see you back on Tuesday.
Yes, sir.
Thank you, Your Honor.
Thank you. Okay, and then Mr. Valero, I think I've got Mr. May here in a different booth.
That should be a plea, Judge. We signed all this stuff yesterday, I think, and had it sent over. Hopefully you have the documents in order.
I've got a plea agreement. I don't have an advice of rights form. Do you know if one of those was signed?
I do not know, Judge.
We will have the jail take him a copy of that form right now. Do you need to speak to Mr. May before?
I don't believe so.
I signed the advice of rights form yesterday.
Yeah, Judge, I had sent those over to the jail. I'm just confirming that they sent those back over to us.
Oh, okay. You can hold on.
Okay. I'm sorry, it's coming to digital signature, but I guess I don't.
Okay, I think I'm satisfied for the moment that we're okay to go forward, and if we don't have that, again, just ask Mr. May to sign another copy, so. All right, so this file 25-22194-FH and 25-22216-FH, People versus Matthew Ryan May. We are here today for a pretrial hearing in both of those cases, final pretrial in the 22194-FH file, pretrial in the other one. First, let me have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Matthew May.
And sir, you are Matthew Ryan May?
Yes, Your Honor.
Okay, Mr. Malero, where are we with Mr. May's cases today?
So, Judge, there has been a plea agreement reached. I'm sorry, can you hear me?
Yes.
Oh, there's been a plea agreement reached as to all files, Judge. As to the 194-FH file, Mr. May will plead guilty to counts 1 and 2 with a habitual offender third notice. And as to the 216-FH file, he'll plead guilty to an added count 2 aggravated assault, 1-year misdemeanor. There is a agreement that Mr. May's sentences will run concurrently. The people shall dismiss the habitual offender fourth notice in the 194-FH file. And the people will dismiss count 1 and habitual offender fourth notice in the 216-FH file. I do not, if there's restitution, we reserve the right to have a hearing on that matter, although no restitution amount has been determined. I believe that involves the plea agreement, Your Honor.
Sir Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is. Thank you.
Mr. May, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Matthew Ryan May, is that correct?
Yes, that's correct.
Sir May, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 25-22194-FH to count 1 and 2, which are both uttering and publishing.
Yes, Your Honor.
And is it also your intention to admit to being a habitual offender, third offense?
Yes, Your Honor.
Do you understand that by pleading to those offenses with the habitual offender third, that the maximum possible punishment for each count of uttering and publishing would be up to 28 years in prison?
Yes, Your Honor.
Are you satisfied with Mr. Malero and the advice that he's given?
Yes, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that, other than as we've discussed on the record here today, is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Malero?
Yes, Judge.
Is that also your understanding, Mr. May?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them.
Okay.
You do have the right to a speedy public trial by jury. You can't ask for a non-jury trial. And if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have the witnesses again to appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. May, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you?
No, sir.
Do you understand that you're giving those rights up?
Yes, I do.
How do you wish to plead to the charge that on or about January 8, 2025 through January 9, 2025 in the city of Adrian County, Glenway, state of Michigan, that you did commit the offense of uttering and publishing?
Guilty.
And how do you wish to plead to the charge that on the same dates, in the same location, that you did commit a second count of uttering and publishing?
Guilty.
And how do you plead to the charge in file 25-22216-FH that on or about March 6, 2025 in the city of Adrian County, Glenway, state of Michigan, that you did commit the offense of aggravated assault?
Guilty.
I don't believe I asked you about that one. So on the aggravated assault charge, you understand the maximum possible punishment for that offense is up to 1 year in jail and or a $1,000 fine.
Guilty. Yeah.
Do you understand that's the maximum possible punishment for that?
Yeah. Yes, sir.
Okay. And you still want to go forward with your plea?
Yes, Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No, sir.
Have you been threatened in any way in order to get you to plead guilty to those charges?
No, sir.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. May to plead guilty today?
No, Your Honor.
Judge, just for the record, there was an estimated guidelines scoring that Mr. Steed and I reviewed, and I did review that with Mr. May. Obviously, the Circuit Court Probation Department would do the official pre-sentence report with the official guideline scoring. And of course, that would be subject to debate and final say with the court. And I've explained that to Mr. May, but I believe that what Mr. Sneed provided was accurate.
Okay, so Mr. May, do you understand that although you've seen an estimation of the guidelines, those aren't the final guidelines because ultimately that's up to me.
Yes, sir.
And so you understand that those possibly could change between now and between the sentencing and what you've seen.
Yes, sir.
And do you still want to go forward with entering your plea?
Yes, Your Honor.
Okay. If your plea is accepted and you engage in misconduct, the court won't be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. You understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, sir, it is.
Mr. Malero, do you want to establish a factual basis?
Sure, Judge. Yeah, Mr. May, is it true, or I should say accurate, that on or about, I think it was April, I hate this computer. On or about January 8th through January 9th of 2025, that you did utter and publish as a true, a false, or forged instrument in writing upon the TLC Community Credit Union?
Sure.
I think one of the instrument, it was a check in the amount of $1,700, and then another one for $1,202.
Yeah.
And you
Yes, sir.
knowingly did that with an intent to defraud TLC Community Credit Union?
Yes, sir.
Is the state and the court satisfied on that particular issue?
I am. Thank you, Mr. Malaro.
Yes.
And then I don't know the date of the other matter. But you got into a fight with someone at the jail. I think was it a person by the name of Dom Shot?
No, Trenton Damon.
Oh, that's right. Sorry. Trenton Damon, you got in a fight with him?
Yes, sir.
And you committed an assault on him, and you didn't have permission to, beat him up or anything, right?
No, sir.
But you in fact did beat him up?
Yes, sir.
And that occurred on or about March 16th, 2025 in the city of Adrian, County of Lenawee,
Yes, sir.
state of Michigan. Yes?
Yes, sir.
Is the court and the state satisfied as to that charge?
Just asked to verify that that did cause a aggravated injury to Mr. Damon's face.
Did you cause an aggravated injury to Mr. Damon's face, Mr. May?
Yes, sir.
And you agree
Thank you.
that did not cause his appearance to be more favorable than before you hit him?
Yes, sir.
Is the court and state now satisfied?
I am. Thank you.
Okay, has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
It has, Your Honor. Thank you.
Mr. Malero?
Yes, I believe the court is.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. May has had full knowledge of his rights to competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for December 19th at 8:15 a.m. Mr. May, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do
Okay.
that, you please be truthful about these offenses and about your background.
Yes, Your Honor.
Okay, Mr. Moore, do you need to speak to Mr. May right now?
No, only if we were releasing him. So no, I do not.
Okay. All right, Mr. May, you can let the officer with you know that you are done with court for today then.
All right, thank you. You have a great day.
Thank you.
Thank you. Judge, did we do a Bradley Rohrbach?
I was supposed to ask you about that. I did that. Mr. Fry was here on the other cases, and I had forgotten that you represent him on one of the 3 cases. So
That's all right. I forgot to, so we're in the same boat. Did it get adjourned, I take it?
it did get adjourned to, do you have the date?
January 14th.
January 14th.
Perfect. Do I need to do a stip and order or anything, Judge, or is Mr. Fry gonna do my job for me?
I would appreciate if you could do one, because I don't know if Mr. Fry knows to do one for all 3 files.
Duly noted, Judge. Thank you.
Okay.
I think that's it for me, Judge.
Yeah, I believe we are all set. Thank you.
Great. Thank you. Have a good day.